Before World War I, there was a different type of war being waged that most people don't know anything about, which I refer to as the War on the Bankers. And let's have a look. In the decades following the Civil War, the US economy grew rapidly with the emergence of large railroad and industrial interests. Unfair and fierce competition prompted the formation of large trusts, like Standard Oil, to control price competition. And below we can see the Sherman Anti-Trust Act was signed into law on July 2nd, 1890. And the first to be hit with this new law was John D. Rockefeller's Standard Oil. Proceedings were commenced against the Standard Oil Company of Ohio, which resulted in the entry by the Supreme Court of Ohio on March 2, 1892. It was alleged that shortly after this decision, seemingly for the purpose of complying therewith, voluntary proceedings were had apparently to dissolve the trust, but that these proceedings were a subterfuge and a sham. And basically what happened was Standard Oil was ordered dissolved in 1892, but they didn't comply and just played lawyer games for the next 19 years, and wouldn't actually be dissolved until 1911. And from the Milwaukee Sentinel, on May 16, 1911, under the headline Standard Oil Dissolved by the Supreme Court, Labor Leaders Go Free, we see a good timeline of the history of Standard Oil. And we can see 1882, the organization of so-called Standard Oil Trust, and then in 1890, the passage of the Sherman Anti-Trust Act, and then in 1892, the dissolution of Standard Oil Trust was ordered, which of course the Rockefellers didn't comply with, and 19 more years of legal arguments and court orders would follow until 1911, when the Supreme Court finally orders the dissolution of Standard Oil. We can see the next volley being launched in our war on the bankers in the Northern Securities case, and we see some familiar faces here, and what they did was pretty much try to have a complete monopoly on the railroads. In 1901, James Hill and D.H. Harriman cooperated with banker J.P. Morgan and financier John D. Rockefeller to create the Northern Securities Company. And then, in 1902, President Theodore Roosevelt instructed his Justice Department to break up this holding company using the Sherman Anti-Trust Act. And fast forward to March 15, 1904. The Supreme Court rules the Northern Securities Company is in restraint of trade and illegal. The suit was instituted by the United States against the Northern Securities Company and the two railroad companies, the Northern Pacific and the Great Northern, and their leading stockholders for the purpose of dissolving the merger of the two roads, which the United States claimed had been created by the organization of a holding company, the Securities Company. This consolidation was claimed to be in violation of the Sherman Antitrust Law. Justice Harlan also discussed the predictions of financial disaster from the enforcement of the antitrust law, but discouraged them from saying they were usual under such circumstances and need not be realized. Justice Harlan declared that the only object of the merger was to prevent competition, and he said that if no one else knew this to be the case, J. Pierpont Morgan, one of the defendants, knew that to have been the case. Extracts from Mr. Morgan's testimony were quoted in support of this statement. So the next target we see the Sherman Act taking aim at would be the DuPonts. And in the morning edition of the Lewiston Daily Sun on July 31st, 1907, we would see that the day before, the DuPont Powder Company was in court. July 30th, 1907, the government today filed in the United States Circuit Court for the District of Delaware at Wilmington, Delaware, a petition against E.I. DuPont and Amirs and Company. The petition relates that all of the defendants are engaged in interstate trade and commerce in gunpowder and other high explosives, and are violating the Act of July 2, 1890, commonly known as the Sherman Anti-Trust Act. And then we see, by June 14, 1912, the DuPonts would lose the case and the company was ordered to be dissolved. Final decree entered against DuPont Concern, violated Sherman law. The final decree was entered in the United States Circuit Court by Judges Gray, Buffington, and McPherson in the government suit against E.I. DuPont and Amirs Company et al., providing for the dissolution. And we can see here that part of the judgment states, the following plants are transferred to the second new corporation, and they list a bunch of former plants that used to belong to the DuPonts, now taken away. But all's not lost, of course, as we can see the E.I. DuPont and Nemir's powder company is permitted to retain the following plants, and then they give a list of those. Next in the war on bankers we see the United States versus the United States Steel Corporation. The Department of Justice indicted U.S. Steel in 1911 with monopolizing the steel industry. And among the owners are some familiar names in J.P. Morgan again, and of course wherever he's involved his son J.P. Morgan Jr. is right there with him too. And we also see Andrew Carnegie was a partner in U.S. Steel as well. And they would learn the lessons from the previous cases we've looked at, as by the time the case was litigated before a district court in 1915, U.S. Steel's domestic market share had fallen to 50%, keeping it safe as a single company since a monopoly no longer existed. And speaking of monopoly, everybody knows the board game Monopoly, but most people don't know that the inspiration for Rich Uncle Pennybags was legendary financier J.P. Morgan. Anyways, if we go back and have a look on October 27th, 1911, we see the headline, "Steel Trust Will Fight the Government Suit. Magnates in Meeting at Morganholm." The Steel Kings will not be ousted from their throne of power without a fight that will become a classic in American legal annals. A meeting of the men higher up in the great corporation was held last night in the famous library of J. Pierpont Morgan's uptown house. And as we can see, about 4 years later, on June 4th, 1915, the Justice Department would make no definite statement today concerning the Steel Trust case, but it was understood on good authority that litigation almost certainly would be taken to the Supreme Court. And then we see about 5 years later, on March 1st, 1920, the headlines read, "Steel Corporation Wins Big Suit." The United States Steel Corporation, the world's most gigantic industrial concern, is not a trust within the meaning of the Sherman Law, the Supreme Court held today. And as we saw, that's because they put off the trial until 1915, and by then had reduced their market share to 50%, which is something J.P. Morgan and his partners didn't do back in 1904, when their Northern Securities Company got broken up. When you look at the battlegrounds in the War on the Bankers in 1913, we see that the U.S. Congress, backed by the U.S. courts, had fired a barrage of Sherman Anti-Trust Act suits that already shattered Standard Oil, and the Northern Securities Company, and the DuPont Powder Company by this point in time. And they had the United States Steel Corporation targeted in their sights as well. So, how do you think the owners of those companies felt about all this? Pretty pissed off, I would imagine. But it's 1913, and as we're going to see, things are now going to start getting really interesting.